So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today, I'm going to take you around the United States to cover some state laws that are going into effect today that you need to know. And I think that you'll be intrigued by what's going on throughout the United States with respect to employment law. There's a whole lot more out there. There's frankly a lot of laws that are going into place on January 1st. But here's 5 big ones that you should know. We're going to start off in California with non-compete agreements. There's quite a few in California, so we'll go through them. But California AB 1076 makes it unlawful to impose non-compete clauses on employees. There's already some case law that supports that in Edwards versus Arthur Anderson, and so it's not completely new, but the new law says that it shall be unlawful to include a non-compete clause in an employment contract or to require an employee to enter a non-compete agreement that does not satisfy an exception in this law. This is honestly just following a broader trend throughout the United States. I think New York's got a law on the books on non-competes, and you're going to be seeing more of this because I think that generally speaking, the Department of Labor has also turned an aim towards non-compete agreements. You know, I don't really have a dog in the non-compete agreement fight. I think that they're fairly rarely enforced, and they even now in red states, there's a very unlikely chance that a true non-compete will be enforced and have really any kind of teeth to it. So again, a lot of these laws are sort of codifying things that have already been codified for various reasons, and we'll be talking about them as we go on. Again, from California is the Discrimination in Employment AB 2188, use of cannabis. This one, I think for many reasons it's long overdue, but I do think that there is some goofiness to this law, right? So it says that it's unlawful for an employer to discriminate against a person in hiring, termination, or any term or condition of employment if the discrimination is based on the person's use of cannabis off the job and away from the workplace. And so fine, that's perfectly. There's kind of a lot of laws similar to this. I don't find that to be particularly weird or strange. I think that's expected. What I don't really understand here is that it doesn't apply to employees in the building and construction trades. When you see this written in there, there was some special interest in the building and construction trades that made this decision, and this is why I think it invalidates much of the law. Personally, I mean, if you have these exceptions like this, what does it mean? Especially because the presumption, of course, I imagine, is that building and construction trades are dangerous, and then if someone's using cannabis outside of work, then that could cause a problem. But what about manufacturing? Right? There are any number of industries out there that specifically could, quote unquote, benefit from this. And so that's what I don't understand. I don't understand that at all. If it's a problem, if it shouldn't be discriminated against, it shouldn't be discriminated against. Or if there's a bona fide safety reason that should be codified in the law, not specifically call out a specific employee in the quote building and construction trades, which is one of my problems. Similarly, is California SB 476, and it provides that time employees spent to complete food handler training and certification is compensable as hours worked, and the employee has to be paid for those hours. And this is kind of goofy, right? So those are, if it's required for the job, those are considered to be hours worked, and federal labor law already supports that if it's a requirement of the job itself. And so the idea that they must specifically call it out does seem to me to be again written by some special interest, not sure exactly who, that hours worked are training is hours worked, and we already know that. Don't know what's happening here. Again, I'm sure that some specific interests were very ingrained in writing that one. The next one up is actually in Arkansas, and this seems to be kind of, I don't know, I would say this is kind of a culture war thing. So it's Arkansas HB 1197, and it specifically surrounds unemployment compensation. So prospective employers can notify the Division of Workforce Services, who administers unemployment in the state, if a candidate doesn't respond to an employment offer or appears for a job interview. This gives them the opportunity to notify the division, and what that may result in is a disqualification for unemployment benefits. I'm not sure about this. Like, I thought they could already do that if it came about. I suppose it has to be audited at this point, but I don't know about this. I don't know about codifying it. I think I understand why it was put into place, but it very much seems like more culture war stuff. The last one is kind of strange for me. It's actually a two for one, I suppose. It's Illinois HB 2493 and Illinois SB 2034. So 2493 requires an employer to provide up to 2 weeks of unpaid leave for an employee grieving a family or household member who has passed away as a result of violence. I guess a crime. So I guess you have to make sure that it was as a result of crime. But I mean, that's, for one, there's an argument to be made that if it's a grieving family that might fall under FMLA potentially. I mean, that's probably a fine line. But anyway, this is a strange one. I think I support it, but this all sort of builds on themselves where any employer who wants to go into Illinois has to be thinking of all of these things that exist just to operate. And it can become, I think, overwhelming if you want to start a business in Illinois. And just it's one of those where if you're going to have a good HR person navigate all of these different laws. The next one up is Illinois SB 2034, which has the same thing, kind of. It's employers that have at least 50 full-time employees are required to provide unpaid bereavement leave if they lost a child by either unaliving themselves or homicide, and the amount of leave depends on the size of employer. I would argue that this could potentially fall under FMLA, and this might be a good thing, but man, it is hard to navigate these type of laws when you're trying to go in, and especially if, for example, you have a remote worker and you only want one remote worker in the area. You've opened yourself up to an unbelievable amount of liability. Now, are these good things? I mean, it's unpaid leave. It will result in the business having to cover it with overtime, most likely. But are they good things? Yeah, but, giving grieving family members, the outlet is a good thing. But it just becomes such a minefield to operate in Illinois. Let me know what you think about these laws that are going into effect today, January 1st, 2024. Welcome to the new year, and I look forward to bringing you more HR content this year. Thank you. Bye.